Hello, everybody. My name is Harold Rabner. I'm class of '64 and trustee of the Dartmouth Lawyers Association. I'm here in connection with the program, but only indirectly, because I'm here to honor a very distinguished alumnus, Dartmouth Yale law alumnus from my class of '64. His name is Roger Aaron. Roger passed away on February 11th of this year, unexpectedly. He was one of the titans of corporate law of my generation, and will always be remembered. He combined a love of Dartmouth with a love of the law in an extraordinary way. And I felt it was particularly appropriate for me to make some of these comments now, because without Roger's generosity and time and effort, undergraduate legal studies we really would not have taken off the ground, including today's lecture. Roger should be remembered as, and he was given the Daniel Webster Distinguished Lawyer Award, Distinguished Dartmouth Lawyer Award, which honored him for his excellence, his integrity, his honesty, belief in justice, and what he combined was the love of law and Dartmouth, where he served as class agent and on the Rockefeller Board of Advisors. I'd just like a moment of silence in his honor, and wish Ginny, Peter, and Todd, both of whom are also alumnus of the college, a farewell from the college. Thank you. Thank you.
Thank you, Hal, for that tribute, and thank you all for coming today. My name is Xander Mize-Bay. I'm a member of the class of '01, and I'm a vice president of the Dartmouth Lawyers Association. I want to also thank people from the Rockefeller Center and the Office of Alumni Relations for helping facilitate this lecture and our Law Day events today and tomorrow. This lecture is a Volk lecture, which is part of a series established in 2004 by friends and colleagues of Stephen Volk, class of '57, and chairman of Credit Suisse First Boston, and formerly a partner at Sherman & Sterling. Now today, for that lecture, I have the great pleasure of introducing one of the most influential people in Washington, a man who, until this year, a few people outside the Beltway had probably heard of. Although it's easy to think of lawyers as aloof, ivory tower-crusted bookworms, few things could be further from the truth. What happens in this nation's courtrooms affects all aspects of American society, and the person whom I would argue has the greatest individual influence on what is discussed in our nation's highest courtroom is the Solicitor General. And since June 2001, that person has been Donald Verrilli, who will speak to us today about the separation of powers and the executive's defense of congressional enactments. Now, some of you might be wondering, what is a Solicitor General? The Office of the Solicitor General is part of the Department of Justice, which is within the executive branch. And in short, the Solicitor General is the federal government's chief lawyer before the U.S. Supreme Court. But in fact, the job involves a lot more. His office is charged with supervising and conducting the government's Supreme Court litigation, which is a tremendous amount of work, given that the government is involved in somewhere between 2/3 and 3/4 of all the cases heard before the court each year. The office's staff attorneys may help prepare petitions and briefs, but it's the Solicitor General who determines in which cases the government will seek review and which positions and strategy the government will take in those cases. He himself either argues those cases or selects someone to do so on his behalf. There are also intangibles to the job. The Solicitor General has a crowded dance card. As one academic put it, he serves the legal interests of his bosses, the Attorney General and the President, but he also must be mindful of the long-term interests of the United States, which at times might conflict with those of the bosses. And he must also respect his responsibility as an officer of the court. It's a delicate dance, but it's one that General Verrilli's illustrious career has prepared him for. Having grown up in New York and Connecticut, General Verrilli attended an undergrad school in New Haven that we don't need to name, followed by Columbia Law School, where he was editor-in-chief of the Columbia Law Review. This was followed by years in private practice with the firm of Jenner and Block, where he specialized in telecommunications, media, and First Amendment law, and rose through the ranks to serve as managing partner of the firm's Washington office. A fitting training for what was to come, General Verrilli also co-chaired the firm's Supreme Court practice, where he argued several cases before the court and was involved in many more. Following the election of President Obama, General Verrilli left the firm to join the Solicitor General's office as a U.S. Deputy Attorney General. He also spent a time in the White House as Deputy Counsel to the President before President Obama nominated him to be Solicitor General, a post he assumed less than a year ago. And what a year it has been. Those of us here might say the highlights are his visits to Hanover, where his daughter is a member of the illustrious class of 2015. But just one look at the nightly news reveals. Activity at the Supreme Court this year has been in the public eye more so than any in at least a generation. What happens in the Supreme Court now will affect the United States for years to come. And time again this year, General Verrilli has been the one at the center of that action, leading the U.S. and its government's charge. Matters such as the constitutionality of the Patient Protection and Affordable Care Act, for which more time was put aside for argument than any case in more than 4 decades, or the legality of Arizona's new immigration law, just argued last week, have made questions and debates of congressional power and the scope of the executive's authority points of dinner table conversation. To shed some light on those questions and more, it is my pleasure to introduce the 46th Solicitor General of the United States, Donald Verrilli.
Thank you, Zandra, for that lovely and gracious introduction. It's terrific to be here and to be part of the Rockefeller Center and part of the extraordinary series of events that the Center's putting on. I'm really privileged to be here. I'm a little concerned that my talk this afternoon is going to reinforce what I think Zandra described as the aloof, bookwormish nature of people in the profession and people in my job. So just bear with me. When we will do the lecture, and then afterwards I'll be happy to answer questions about the topic of the lecture or anything else. So my topic today is the separation of powers and the executive branch's defense of statutes. You may ask yourself what separation of powers issue there could be here. The Constitution gives to Congress the authority to make laws. The Constitution gives to the courts the power to decide the constitutionality of laws, and it gives to the executive branch the power to enforce the laws and to defend them when they're challenged in court. So for separation of powers purposes, the world is round, it sounds like. But must the executive always defend federal law, no matter what the executive branch's view is of the constitutionality of that law? Or is the executive free to make its own judgments about a law's constitutionality and decline to defend in court laws that it concludes are unconstitutional? Does the Constitution's text answer that question? Do fundamental separation of powers postulates that we derive from the Constitution answer it? What light does our constitutional history shed on that? And why does this question matter? So I've chosen this topic because decisions about how and whether the United States will defend statutes are an important part of the role I play in the position I have now. And I've chosen it because it's a subject that continues to be the source of some confusion and controversy. And I should state at the outset that the views I'm expressing today are my views. I'm not speaking on behalf of the United States government today. I also want to note at the outset that I'm not going to be addressing the subject of the Defense of Marriage Act directly and of the decision of the administration not to defend it. When that decision was made, I was recused from participating in the decision because my former law firm had been involved in the litigation. My recusal period is now expired, but that litigation is ongoing, and it's part of my responsibilities to manage it, and therefore wouldn't be appropriate to talk about that specifically. And I'm going to be talking instead about the general principles that govern in this area. So what I propose to do this afternoon is first to talk at a general level about the sources of the executive's responsibility to defend congressional enactments when they're challenged in court as unconstitutional. and in particular to examine the separation of powers values animating the competing theoretical views about the existence and scope of that responsibility. I then want to turn to the historical practice and look at it, and in particular the two categories of cases in which it has been recognized over time that the executive branch can decline to defend statutes that are challenged in court as constitutional. First category being statutes that are that the executive believes are an impermissible infringement of the executive's authority under the Constitution. Second category being statutes that the executive concludes, for which the executive concludes there's no reasonable argument in defense of their constitutionality. So let's start with the source of the responsibility to defend statutes. The topic that I've chosen presupposes that there's a decision to make that the executive, whether the executive branch will defend a statute, but not everybody agrees that there is. One school of thought holds that the president is obliged to enforce and therefore to defend in court every validly enacted congressional statute, whether or not the president believes a statute is unconstitutional, and whether or not the president believes that the statute is an impermissible infringement of the president's own authority under Article 2 of the Constitution. Those who hold this view grounded in the requirement in Article 2 of the Constitution that the president take care that the laws be faithfully executed. The argument's premised on the notion that the president has no independent authority to trump the constitutional interpretations of the other branches. If a president is faced with the task of enforcing and defending a law that has been enacted by Congress, then by definition it was passed by a Congress that believed it was acting constitutionally. In fact, members of Congress have to take an oath under the Constitution to support the Constitution, just like the president does. And the law would either have been signed into law by a president or enacted by a veto override if the president has vetoed it, and therefore in conformity with the requirements of the Constitution. And ultimately, of course, as Marbury against Madison famously said, it's up to the judiciary to say what the law is. So unless the judiciary has definitively ruled that a law is unconstitutional, the president must, on this view of things, enforce it. And if the president must enforce it, the executive must defend it when its challenge is unconstitutional. Lest you think that this is purely a matter of theoretical interest, it's worth recalling that in our history the House of Representatives voted articles of impeachment against the president, and the Senate came within one vote of removing that president based on their reaction to that president's refusal to enforce a statute that he believed was an unconstitutional infringement of his powers. President Andrew Johnson refused to abide by the restrictions of a statute called the Tenure of Office Act, which had been passed over his veto in 1867, and which required Senate concurrence in the president's removal of any official that the Senate had to confirm in the first place. The point of that Tenure in Office Act was to block President Johnson from removing the Secretary of War, Edwin Stanton. Stanton, in that role as Secretary of War, was committed to carrying out the more aggressive Reconstruction policies of the radical Republicans in Congress. President Johnson opposed those policies. Johnson thought the Tenure of Office Act was an unconstitutional infringement of his Article 2 authority to take care that the laws be faithfully executed, on the theory that if he's unable to remove inferior officers in the executive branch who refuse to carry out his commands about how the law should be enforced, then he can't fulfill his constitutional duties. So based on that belief, he ousted Stanton, or attempted to oust Stanton, without going to the Senate to get their concurrence. The House of Representatives responded 3 days later by voting articles of impeachment, many of which rested on the notion that Johnson's violation of the Tenure of Office Act, his refusal to enforce it, was a high crime or misdemeanor sufficient to justify impeachment. Now, the Senate, as we know, fell one vote short of the 2/3 needed to remove President Johnson from office. But the understanding of the president's responsibilities that supported the articles of impeachment against him actually has continued to command support in some academic quarters. And that's so even though in our constitutional history, President Johnson's view has been vindicated. In a 1926 case called Myers against the United States, the Supreme Court held that a successor statute that was premised on the Tenure of Office Act was an unconstitutional infringement of the president's Article 2 authority. But the view that I just described, the view that the president must enforce and defend all laws on the books under all circumstances is not the dominant view, and it's for reasons I take to be very good reasons. And perhaps the strongest refutation comes from the very language of the Take Care Clause, the clause in the Constitution on which that view is premised. And the Take Care Clause obligates the president to take care that the laws be faithfully executed. But what is the Constitution if not one of the laws that the president must take care to faithfully execute? In fact, under Article 6, the Constitution is the supreme law of the land, over and above anything Congress enacts and over above any state laws. And therefore, there's an alternative view of this, that the president, and that view is further backed by the oath that the president must take to protect and defend the Constitution of the United States. And so necessarily this alternative view holds that the president has to have the authority under the Constitution to vindicate the Constitution if, in his judgment, it conflicts with an act of Congress. And that view implies that there are circumstances in which the president's constitutional authority allows him to decline to enforce and also to decline to defend in court an enactment that he believes is unconstitutional. Now, some take that alternative view to the opposite extreme and argue that the Take Care Clause, or the Take Care Clause and the oath together oblige the president to refuse to enforce and therefore also to refuse to defend in court any statute the president believes to be unconstitutional. The view reads into the Take Care Clause not only an obligation to decline to enforce, but also an authority on the part of the president, and I think this is the way to think about it, a precursor authority on the part of the president to make independent constitutional judgments. And those judgments would be independent of the Congress that enacted the law, which, after all, must have believed it was constitutional to do so if it enacted the law. And it would be in advance of the judiciary making any final judgment about the law's constitutionality. And so the strong forms of this view suggest that the president always has this authority and always has an obligation to act not to enforce or defend laws that the president independently concludes are unconstitutional. There are softer forms of the argument that suggest that the president possesses at least discretion to decline to enforce and to decline to defend, but can exercise that discretion case by case. Now, in reality, our constitutional practice has settled in a place between the two polar extremes I just described. On the one hand, we have long accepted the proposition that there are situations in which the executive can legitimately decline to enforce and to defend a validly enacted statute. And in fact, Congress put a statutory procedure in place, a provision called 28 U.S.C. 530D, that requires the Department of Justice to send a notification to the leaders in Congress whenever the department decides that it is not going to defend an act of Congress in court. And the very existence of this provision is widely understood as a recognition by the Congress of the validity of the executive practice of declining to defend a statute in appropriate circumstances. On the other hand, the executive has not traditionally exercised anything resembling a broad authority to decline to enforce laws or decline to defend statutes in court whenever the president or the executive branch reaches the conclusion that a statute is unconstitutional or of doubtful constitutionality. Instead, there are two carefully defined circumstances in which the executive has asserted that authority. The first is the situation that encompasses statutes that the executive believes are unconstitutional infringements of the executive's own Article II power. And the second is the encompasses statutes where the executive branch makes a judgment that there is not a reasonable argument to be advanced in defense of the constitutionality of the statute. I want to take a closer look at each of those two categories to see what they tell us about the relationship between the constitutional separation of powers and the executive's responsibility to defend federal statutes in court. I'm going to turn first to the question of statutes that the executive believes infringes in its Article II authority. The legitimacy of the Department of Justice's refusal to defend statutes that the executive believes infringe Article II authority is really pretty well established. It stretches back to the 1926 case of Myers that I mentioned earlier in connection with President Johnson's impeachment. An act of Congress purported to block the president from removing the Postmaster General without the advice and consent of the Senate. The president defied the statute, dismissed the incumbent Postmaster General. The Postmaster General then sued, said, I want the salary I'm not getting since you kicked me out of my job and I want my job back. when that case reached the Supreme Court, the Solicitor General appeared on behalf of the United States, but not to defend the constitutionality of that statute, to attack the constitutionality of that statute as an unconstitutional infringement of the President's Article II authority, based on the same rationale that Andrew Johnson had relied on in defying the Tenure of Office Act, namely that if you're running the executive branch of government, you need to be able to control the officers who are carrying out, who are executing the laws, and if you can't fire them, you can't control them. Now, the Supreme Court agreed that the statute was an unconstitutional infringement of the President's authority, and that the President had acted lawfully and within his powers in defying it. And not one member of the court in that case suggested that the President or the Solicitor General had acted in an inappropriate manner in refusing to enforce the statute and in attacking it rather than defending it in court. The court did not say that the President was required to stay his hand until the court declared the statute unconstitutional. Another historically important example occurred during World War II in a case called United States against Lovett. Congress enacted a war appropriations statute that included a provision prohibiting the use of funds to pay the salaries of 3 unfortunate named individuals who the Congress apparently thought had communist affiliations. President Roosevelt signed the legislation into law because he concluded it was necessary to ensure that those appropriations were available for the war effort, especially during an upcoming congressional recess. But he announced his view that the provision I just described was an impermissible intrusion on his executive authority, as well as an unconstitutional bill of attainder, because it singled out named individuals for punishment. The 3 individuals brought suit seeking to get their pay. The executive branch declined to defend the statute. When the case eventually made its way to the Supreme Court, the Solicitor General appeared to attack the constitutionality of that congressional enactment, principally on the ground that it impermissibly interfered with the President's authority over executive appointments and removals. The court ended up striking the law down on bill of attainder grounds, but again, the court made no suggestion that the executive branch had done anything other than act appropriately by refusing to defend the statute and actually coming into a court and attacking it. And over the years, the Solicitor General has appeared in the Supreme Court to challenge the constitutionality of legislative veto statutes, to challenge the constitutionality of the independent counsel statute, and to challenge the constitutionality of other statutes that the executive branch believed were infringements on the President's Article II authority. I actually argued a case of that kind earlier this term. It's called Zivotofsky against Clinton. In 2002, Congress enacted, as part of an omnibus authorization statute, a provision that was relevant to the question of whether Jerusalem should be considered the capital of Israel. What the statute said was that any American citizen born in Jerusalem had the right to have on his or her passport Israel listed as the country of birth. Now, as far as the executive branch was concerned, that statute was a problem because since Israel was founded in 1948, every president has taken the position that the United States does not have a view on whether Jerusalem is part of Israel, and that has to be worked out by the parties in the Middle East. So President Bush in 2002 signed this appropriations law into law, including this provision. He did so for much the same reason that Franklin Roosevelt signed the law into effect that I described in the Lovett case, that he wasn't going to veto this entire law and everything it did because of one provision that he found unconstitutional. But he did decline to enforce this provision, and his State Department was instructed not to list Israel as a country of birth for American citizens born in Jerusalem. President Obama continued that policy when he took office. An American citizen born in Jerusalem brought a lawsuit saying, I have a right under this statute to have Israel listed as my place of birth. Lower courts addressed this issue, and the United States appeared in lower courts not to defend the constitutionality of the statute, but to attack it as an unconstitutional infringement on the President's authority, that the President has authority over foreign relations under Article II of the Constitution, and in particular has the authority to decide, without Congress's input, when the United States will recognize a foreign country and what its borders will be. And the case worked its way through the courts, and there were 2 issues, that one I just described, and then another issue called a political question doctrine issue, which is this the kind of thing that should be in court at all? When the case got to the Supreme Court, I argued on behalf of the United States that this statute was an unconstitutional infringement of the president's authority. So again, an example of a situation in which the Solicitor General appears on behalf of the United States to tell the Supreme Court that an act of Congress is unconstitutional. The court ultimately didn't resolve that question of Article II authority. It decided that the case didn't, in fact, present a political question, that this was a constitutional issue that the courts could decide, and it sent it back to the lower courts to take a look at the underlying issue in the first instance. But case does, I think, reinforce the idea that it's uncontroversial in at least certain circumstances for the executive branch not only to decline to defend, but to affirmatively attack the constitutionality of certain statutes. And so if we accept that historical practice as legitimate, as the Supreme Court seems pretty clearly to have done, it pretty conclusively establishes one thing, which is the view, the first of the two polar views I described earlier, can't be squared with our historical practice and with the Supreme Court's view of the proper allocation of authority, because we have situation after situation in which the executive branch has declined to enforce and declined to defend a statute based on these separation of powers concerns. And that is so even though the Congress that enacted the law thought it was constitutional, and it's so even in advance of the Supreme Court declaring the law unconstitutional. But it's unclear how much this first historical category actually establishes. One might justify the executive's decision not to defend in this category on the ground that if the executive branch actually defended the statute's constitutionality, that would leave undefended the position that the statute violates the separation of powers by impermissibly infringing on the president's authority. So one could argue that the separation of powers values embedded in the Constitution actually require the executive to assume the posture of attacking rather than defending the statute in court, so that the courts will be presented with the ability to decide in an appropriate adversarial context whether the statute is an impermissible encroachment on the president's authority. Or at least one can conclude that it's not inconsistent with separation of powers values for the executive branch to refuse to defend statutes in this category. So let's now go to the second category, the category of cases in which, irrespective of whether the statute is perceived as an infringement on the president's Article II executive power, the executive branch concludes that there's no reasonable argument to be made in defense of the statute. This is also an executive branch practice that has gained acceptance over the years. And at some level, it makes a great deal of practical sense. To take one example, in the 1970s, the Supreme Court issued a series of decisions under the Equal Protection Clause saying that classifications in the law based on gender had to be subjected to heightened judicial scrutiny, meaning that gender-based classifications were not presumptively valid and required special justification or they would be struck down. Now, there were hundreds of federal statutes on the books at that time that made gender-based classifications, and the Supreme Court's decisions threw virtually all of them into serious constitutional doubt, if not ensuring their unconstitutionality. The executive branch could have made a judgment to fight out each one of those, statute by statute, would have consumed an enormous amount of resources of the judiciary and of the executive branch. Instead, the Department of Justice decided it just wasn't going to defend any of those statutes anymore because there wasn't a reasonable argument left to make in defense of their constitutionality in view of the law that the Supreme Court had made on gender-based classifications. Now, the difference between this second category and the one I described earlier involving the incursions on Article II authority of the president is that this second category asks the question of whether there are reasonable arguments to be made in defense of the constitutionality of the statute. And as the word reasonable, I'm sure as you're all thinking, that requires judgments. It's a judgment call about the strength of the case that can be made in defense of the statute. And judgments of that kind are open to being contested in a way that judgments about whether a statute is impermissibly infringing on the president's Article II authority aren't. To begin with, there's a question of where do you set the bar to make these kinds of judgments? What does it mean to say there's no reasonable argument to be made in defense of a statute? If one thinks that the executive's responsibility to defend congressional enactments is, or at least approaches, a constitutional imperative, might make sense to adopt what lawyers describe as the Rule 11 standard. I know there's some lawyers in the room who know what that means, but the Rule 11 is a rule of the Federal Rules of Civil Procedure which essentially requires lawyers who file pleadings in court to attest that there's a reasonable basis in the fact and the law for the representations they're making to the court. There's a very low threshold. Essentially, anything stronger than a frivolous argument meets Rule 11. So if one were applying that kind of standard in this situation, you could say, well, even though there's binding Supreme Court precedent that forecloses the constitutional defense of the statute, that you could always argue as a lawyer that that binding Supreme Court precedent should be overruled. And so you have a non-frivolous basis for defending the statute. But that's not the kind of standard that the Department of Justice and its lawyers apply to any case, much less one involving the defense of statutes. That we apply in the department a much more rigorous standard, and we have standards of candor and professionalism and respect for precedent that put us in a different position from the private litigants who are bound only by the Rule 11 standard. We're not, for example, going to routinely make arguments that Supreme Court precedent should be overruled. The United States has a very strong interest in the stability of the law and respect for precedent, and it wouldn't do our reputation very much good with the court if we were running in all the time telling them that they ought to overturn their precedents. And beyond that basic threshold question, there's a question of, well, just how plausible does an argument have to be before it's a reasonable argument? Many decisions in this category are going to involve predictions about what the Supreme Court will do. And so is it enough that an argument will predictably garner at least one vote from the Supreme Court? Is that enough to make it a reasonable argument to advance, if you can predict that you'll get one vote? Or is it a higher threshold? In our history, there are examples of cases in which the department made a decision not to defend the constitutionality of a statute that at least one Supreme Court justice eventually voted to uphold. We had one of those this year, in fact. There's a case called Coleman against Maryland Court of Appeals. The court in that case, by a 5-4 vote, held that a provision of the Family and Medical Leave Act, the so-called self-care provision that allowed individuals to have time off to take care of themselves if they had a medical ailment, could not constitutionally be enforced against state governments as employers because it would abrogate their sovereign immunity in an impermissible way. Now, about 10 years ago, the Department of Justice made a decision that it was no longer going to defend the constitutionality of this self-care provision of the Family and Medical Leave Act because changes in the law of sovereign immunity were such that it rendered it no longer reasonable to continue to defend the statute. But as the case worked out, it was decided by the Supreme Court by the narrowest of margins, a 5-4 vote. Well, does that make it an unreasonable judgment on the part of the lawyers to have made that decision 10 years ago not to defend the statute? I don't think so. I think this is a situation in which, because what you're doing is exercising judgment, the judgment is, it's not a clear yes or no answer. It's a judgment call, and judgment calls sometimes look differently a few years down the road in 20/20 hindsight than they looked at the time. And precisely because these matters involve the exercise of judgment, and these judgments are necessarily imprecise, there are occasional decisions on the part of the executive branch not to defend a federal statute or even to attack it in court that appear to some commentators not to fit into either of the two categories I described, but instead to just reflect a different kind of judgment, a conviction by the Attorney General or even by the President that the statute is unconstitutional. Even if it could be reasonably defended, it's unconstitutional, we're not going to defend it. A case often cited in this category is a case called Metro Broadcasting versus Federal Communications Commission, which was before the Supreme Court in 1990. That case involved a challenge to minority preferences that the FCC used in allocating broadcast licenses. The preferences at issue in the case were actually made on the basis not of a statute, but regulatory judgments by the FCC. But Congress enacted a series of statutes, appropriation statutes, which forbade changing the FCC preference policy, and Congress had enacted other statutes that had similar FCC preference policies in it. So in reality, it really was a case about the constitutionality of Congress's judgment that these preferences should be implemented. Now, in that case, the United States declined to defend the provisions, the FCC's minority preference provisions. In fact, the United States Solicitor General appeared in the Supreme Court and challenged the provisions as unconstitutional. as a violation of equal protection because they weren't justified, because they were race-based and they weren't justified by a compelling interest in the United States view. Now, in that case, the Supreme Court actually upheld the constitutionality of the statute that the United States had declined to defend and was attacking, and upheld it by a 5-4 vote. Now, of course, a few years later, in a case called Adirondack Constructors, the Supreme Court overruled Metro Broadcasting and held that these kinds of minority preferences, absent a compelling governmental justification, were violations of equal protection. So, given that the court actually upheld the provision that the United States refused to defend, maybe it's understandable in hindsight that some would say that this wasn't a judgment consistent with those historical categories. But again, I think that's 20/20 hindsight, and that decisions look differently after the fact than they do when you're making them. And so I don't think it's fair to describe that as a departure from the usual norms. But the example does point up another question regarding these category of cases, which is to what extent does your decision about whether there's a reasonable argument to defend require you to think about not only where the law is, but where the law may evolve to go. And in thinking about that issue, it's useful, I think, to think about an analogous set of circumstances. The United States often files friend of the court briefs, amicus briefs, in cases where the constitutionality of a federal statute isn't at issue, but the federal government thinks it has an important interest at stake. One example from a not too distant past is a case called District of Columbia versus Heller. That's a case in which the Supreme Court ended up holding that the Second Amendment protected an individual right to bear arms. In that case, the United States filed one of these friend of the court briefs in support of the proposition that the Second Amendment should be read to grant an individual right to bear arms, and that laws limiting the right to bear arms should be subjected to serious scrutiny by the courts. Now, the United States made that argument even though there are many federal laws that regulate the right to bear arms and might therefore be made subject to constitutional challenge and heightened judicial scrutiny under the position the United States was advancing. Even more significant in my mind is a series of positions the United States took in the years leading up to Brown against Board of Education in 1954. In those years, in a series of briefs, the United States took the position that the separate but equal doctrine of Plessy against Ferguson was wrong and should be overruled by the Supreme Court. It filed friend of the court briefs in two cases, one called Sweat against Painter and one called McLaren against Oklahoma, which challenged separate but equal in the context of state graduate schools. In both of those cases, the United States said, get rid of Plessy against Ferguson, no longer good law. In neither case did the Supreme Court reach that issue. It decided that the separate wasn't equal, that the graduate schools were not equal in quality to the availability of graduate programs for whites, and that the statutes were unconstitutional for that reason. And they're related to this. There was a quite extraordinary case also in 1950 called Henderson against the United States. The United States, this wasn't an amicus case, and it actually wasn't about a federal statute, but it's closely related to what I'm talking about here. The United States was a party in this case, and what was the issue in the case was this: an African-American railroad passenger brought a lawsuit challenging the practice of a railroad of having segregated dining cars. He didn't challenge that as unconstitutional because it was private action. What he said is the Interstate Commerce Act, the federal statute, bars discrimination between equally situated people, and these separate dining cars are discriminatory. And the Interstate Commerce Commission first heard this matter before it went to the courts. The Interstate Commerce Commission said, well, no, Plessy against Ferguson is good law, and so what the railroad did is fine. Then that case went into the courts. Mr. Henderson kept challenging it, went into the courts, and the lower courts held, with the United States defending this position in the lower courts, that there was nothing wrong with what the railroad did because Plessy against Ferguson validated separate but equal. Mr. Henderson takes his case to the Supreme Court. In the Supreme Court, the United States did something quite different. It reversed its position, and it did something that's very unusual. It confessed error, said what we said in lower courts was wrong, this judgment is wrong, it should be reversed. And it said it should be reversed because Plessy against Ferguson should be overruled. And it said something else of great consequence. It said, and the Equal Protection Clause, which is in the 14th Amendment and applies by its terms only to state governments, should be made applicable to the federal government through the Fifth Amendment. That you should interpret the Fifth Amendment guarantee of due process, which does bind the federal government, to incorporate the 14th Amendment requirement of equal protection, which before that had applied only to the states. And so you have to think about what the United States government did when it took those steps, right? For one thing, Congress had enacted a series of laws that are most fairly read as mandating segregated schools in the District of Columbia. So it was advocating a position in the Supreme Court in the Henderson case that would make those statutes unconstitutional. And beyond that, it was saying, apply the principle of equal protection to everything the federal government does. And that put in legal jeopardy a whole host of policies that the federal government had implemented in the many decades before 1950. Just to take one example, public housing policies were often designed with racial segregation in mind in periods before 1950, and all of those would then be subject to constitutional challenge as a result of the judgment the United States made and told the Supreme Court what the law should be. So now these, and then of course you get to Brown against Board of Education in 1954, and the United States again comes in and says Plessy should be overruled, and the court accepts that proposition. And in the companion case to Brown in 1954 called Bowling against Sharp, that was a case about the segregation of DC public schools and these constitutional statutes. That's the congressional statutes, rather, that I mentioned. And the United States took an interesting position with respect to those statutes in that case. It said, well, you could read them as mandating segregation, in which case they would be unconstitutional, but you should read them as not mandating segregation, but just presupposing segregation. And if you read them as not mandating segregation, you can interpret them as still being constitutional. So the United States was able to take its position without actually attacking the federal statute in that case, although for all practical purposes, of course, it was, because the District of Columbia was maintaining separate but equal segregated schools under those statutes. Now, of course, as a formal matter, this friend of the court situation is different from the question of whether the federal government is actually going to defend a statute that is when it's attacked in court. But they do point out, but that series, I think, of actions does point up the complexity of the kinds of judgments that the executive branch has got to make when it's deciding the positions it's going to advance in front of the court. So what do we take away from the second category? First, I think as with the first category, the historical record pretty conclusively refutes the view that the executive must in all circumstances defend the constitutionality of statutes. Second, the history also shows that a decision not to defend is a serious one. There aren't very many examples of this, and that these decisions will occur only rarely. And the range of the decisions is bounded. I mean, the executive branch hasn't asserted a broad authority to decline to defend whenever it wants. It's asserted the authority to decline to defend in the two circumstances I've described, and that those circumstances are shaped, I think, by a reflection of, a respect for separation of powers values. And third, because the second category involves an exercise of legal judgment in a way that the prior category doesn't, there inevitably is going to be more dispute about whether a particular exercise of that judgment is on the right side or the wrong side of the boundary. And fourth, it probably shouldn't be any surprise that the most difficult and contested of these judgments in the second category involve the question of how principles of equal protection law apply. So to sum up, I'm not going to offer any definitive judgments about this as a government official. That's sort of the nature of what I do. But I will say that this is an area in which those who crave pure answers and fixed lines of demarcation are not going to find much comfort. And because any individual decision in this area is a matter of judgment, it's open to dispute. But the thought I'd like to leave you with is that you probably should find some comfort in the fact that the judgments about the defense of statutes have been made with an appropriate recognition of separation of powers values, that the decisions to defend are rare, that they're done, I think, uniformly in the best of faith, in the exercise of careful judgment by the executive branch. So with that, I will conclude, and I'm happy to answer questions on this or any other topic that I can talk about.
We're going to have microphones, so if you, and I will prompt you as they raise their hand. I see Professor Dutu already has. So we'll start with Tim. And I'm going to remind you and paraphrase Justice Breyer when I do it to say, you can ask a question about a pending case, but you may not get an answer.
Right.
But yes, you don't have to limit yourself to the topic of today. And go ahead.
Thank you very much, Xander. Thank you very much. I have two questions. One is there any language in the framers' documents as to where they got this take care language, if there's any history on that? And the second question is whether, on the basis of that doctrine or the practices that you've described, the legacy of signing statements, when the president does sign a law into act, but also issues a signing statement to say, this is what I think this law means, is that also covered under the take care language or the practices you've described?
So with respect to the first, I don't know the answer. I don't know what the historical record shows about the clause. With respect to the second, as I think the sophistication of your question implies, the use of signing statements is a matter of some dispute. What I can say about that is that President Obama, in the early part of his administration, put out a presidential memorandum in which he indicated that he thought that there were appropriate uses for signing statements. And examples, if you look at the historical examples of, say, the statute that was at issue in the Zivotofsky case that I described, the Jerusalem statute, or the statute that was at issue in the Lovett case, presidents are in a position often where a highly controversial provision, something the president believes is unconstitutional, is embedded in a statute that is what in the lingo of Washington is called a must-pass statute. In other words, it may be funding the operations of a significant segment of the government or authorizing the operations of a significant segment of the government. And it's just not practical to think that because of that single embedded provision that a president is going to veto the entire legislation and bring a huge part of the government to a grinding halt because it isn't going to be funded. So one function of signing statements is to deal with that kind of a situation. And there are others that the president outlined in his memo, but what the president's memo suggested is that signing statements need to be used in a very judicious manner, very carefully, and infrequently. And I think that's been the practice. I actually think it's a practice of most presidents. I think it's been the practice of this one.
Hi, can you talk about the California gay marriage case at all, and how does your analysis change if potentially there's no one who's able to defend a statute?
Well, the California gay marriage case is not a case that the United States is participating in, and it's not in the federal, it's not in the Supreme Court at this point. It's a case that may get to the Supreme Court, and if it does, it'll then become part of my responsibility to decide what, if anything, the United States is going to do, and so that's a very long way of saying I can't talk about it. But with respect to the second question, it's really a good question. What happens as a practical matter? In a situation where the United States doesn't defend, part of the 530D notice that goes to Congress is so that Congress can make alternative arrangements to provide for a lawyer, if Congress chooses to do so, who can, and then the terms on which that lawyer participates, whether it's as a friend of the court or a party, is something that's open to dispute and is unsettled. But the participation of the lawyer to come in and defend in that situation is pretty well established, and that's what tends to happen. Or other things can happen. In the Metro Broadcasting case I described, the Federal Communications Commission is an independent agency. It's not part of the executive branch for all purposes, and so it itself defended its minority preferences, even though the United States government was attacking them. So they can get taken care of that way. And it does point up something interesting, I think, which is that in situations, and Lovett's a good example of it, sometimes presidents will enforce a law, but then not defend it in court. And in Lovett, the president stopped paying the three people, but refused to defend the law in court. And so the consequence of doing that, one could say, of doing that, continuing to enforce but not defend, is consonant with separation of powers values, because the judgment of the Congress that enacted that law continues in force. The law is being enforced. The authority of the judiciary to have the last word is respected, because the government's enforcement of the law creates a concrete controversy that the judiciary can then resolve. And so it's the argument is that that way of doing things is consonant with separation of powers values in a way perhaps that declining to enforce a law as well as declining to defend it might not be. Now, not everybody agrees with that point of view, of course, but I do think there's an argument to be made there.
This gentleman right.
I'd like to thank you.
One second, please use the microphone, sorry, for recording purposes, thank you.
I'd like to thank you for a very wonderful presentation and for an indication of the genius of American law, particularly for somebody who's served at the American Embassy in Paris and looked at the French legal system, where you have this kind of attempt to have the kind of direct, perfectly legal system that doesn't understand the fluidity of case law and its ability to understand changing judgments. And I think that's particularly important because of the Article 8, Section 1 provision that Congress can act for the common defense and general welfare. I was going to ask you whether you thought if the health care case came up, you could defend it under the term that public health, communicable disease, is directly connected to general welfare.
So the healthcare case is one of those things I'm not going to talk about. It's been a consistent policy of all solicitors general not to discuss cases that are pending before the court, other than in their briefs and the argument they make to the court, and I'm certainly going to adhere to that. So.
I have a question about the relationship of the Solicitor General to the Attorney General. And I'm particularly interested in that second category that you described, cases where the question is whether the constitutionality of a statute can reasonably be defended. And I was wondering, when each new administration comes in, does the Attorney General's office make its own determination as an initial matter about where in the, between the two polar extremes that you described, defend everything, always exercise your own independent judgment? Is that something that's decided anew by the Attorney General with each administration, or is it pretty much left to the Solicitor General to implement on a case-by-case basis?
So let me answer it this way. First, as a formal matter and as a real matter, the Attorney General possesses the authority to decide what position the United States is going to take in court. The statutes that grant the Attorney General that authority. There are regulations that delegate it from the Attorney General to the Solicitor General. So the Solicitor General is exercising a form of delegated authority, but there's a long tradition that the Solicitor General exercises that authority independently. Now, it's not an independence like a judge has. The Solicitor General doesn't have life tenure, the Solicitor General serves at the pleasure of the President. But there is this tradition of independent judgment, and the Solicitor General's job is to exercise that independent judgment. The Solicitor General is subject to being overruled in that judgment by the Attorney General, or supposed even by the President. But what the Solicitor General has is two things. One is the power of persuasion, and the other thing is the option of resigning. And so those are the tools the Solicitor General uses to continue to preserve the ability to exercise independent judgment. Now, as it applies to the category of cases we're talking about, I think the answer that I would give to your question is neither thing is true. I think it's more, I guess the way I would describe it is almost kind of a Burkean sense of things, that the two categories I've described have evolved over a long period of time through the exercise of individual judgment. And I think every Attorney General, every Solicitor General, every executive branch understands that these are weighty judgments, that you're going to make a judgment not to defend only in circumstances where you're powerfully convinced that that's the right judgment to make. You're going to do it rarely, and that is necessary to preserve stability. and that's something I think that every administration shares. So I don't think any, having been only in the beginning of one administration, I can only tell you about this one, but I feel quite confident that it's not the kind of thing that anybody thinks is kind of up for grabs at the beginning of an administration.
To what extent do you think the president is active in, I guess, talking to the Solicitor General, Attorney General, when it comes to cases that the U.S. has to address, at least in your experience?
So one thing that governs the conduct of lawyers is something called the attorney-client privilege, and that would govern conversations of the kind you're describing. And so in my experience, I certainly wouldn't be possible to talk about any specific matter. What I will say in general is that this president, like his predecessors, is a very, very busy person, and the ins and outs of what position the United States is going to take in a particular matter are usually not all that high on the president's to-do list. And I think the president trusts the Attorney General and the Solicitor General to carry out their functions in a responsible way. And so, I think there's not you might envision that there's a fair amount of that kind of interaction, and reality is, I think, in every administration that there isn't.
I was just wondering, how difficult is it for you in what has historically, and I'm sure what continues to be, considered a very professional, non-political operation to operate in a overtly politicized environment in Washington?
You really want me to answer that? So, I guess a couple things about that. What solicitors general say about their job, what I'd say about my job, and what my predecessors would say is that Solicitor General feels like he or she is the custodian of the long-term interests of the United States. And whatever the environment might be, those interests are interests you do your best to discern and then to act upon. And the reality is, for a lot of the large majority of the positions that any Solicitor General is going to authorize in court or take personally in court aren't going to change a huge amount from one administration to another and from one atmosphere to another because they're institutional interests and they're consistent over time, and your job is to advance them and defend the interests of the country. There is a category of cases that all Solicitors General recognize where it's not only consistent with the institutional interests of the United States, but expected that administrations will make legal policy judgments that could differ from each other. Some administrations think the antitrust law should be enforced more vigorously than other administrations. There are judgments of that kind that you make. Those are legitimate judgments. But again, the way you're making them is by your own sense of what's in the long-term institutional interest of the United States. And you may have a different view of that than somebody who's coming at it from a different perspective, but that's the touchstone for making your judgments, and you try to make them. The one thing about the Solicitor General's office is that it's really a remarkable place. There are 20 some odd lawyers, 21 lawyers or so in the office. And they're, aside from one deputy, they're career lawyers. And the 3 of the 4 deputies have been there decades. And then the young lawyers are career lawyers. And they're about evenly divided between people who you would consider politically conservative, people who you consider politically liberal. It's one of the few places in Washington now where that doesn't matter. These people get along great as friends and colleagues and work together, and there's no ideological divide in the office. And people who are politically liberal are going to be advancing positions on the part of the United States sometimes that are going to be, that the world would think of as politically conservative. People who are politically conservative are going to advance positions on behalf of the United States in that office that people outside would think of as politically liberal. These people think it's their job. And so because you have that kind of an atmosphere in the office, it's really not that hard to maintain your view of your focus on the interests of the United States and vindicating the interests of the United States and trying to make sound and sober judgments about what that is.
I see one hand way up in the back. I think will be our last question.
You spoke of the freedom given to the Solicitor General in deciding whether to contest a law, you know, before it reaches the Supreme Court. And we had somebody earlier describe a difference between the American system and the French system. After it reaches the Supreme Court and the Supreme Court has decided, do we then shift into a situation like the French system? Or are there cases where, you know, there is still some freedom on the part of the Solicitor General to contest or not enforce a law?
Well, the Solicitor General doesn't make the enforcement decisions. The Solicitor General just decides what positions will advocate in court. But in general, of course, Marbury against Madison established the principle of judicial review. And although there are theorists and sometimes political figures who take the position that each branch of government gets to make its own judgments, and that even though the Supreme Court has spoken, that the President doesn't have to follow it or the Congress doesn't have to follow it, that's not the norm. And the norm is once the Supreme Court has spoken, the Supreme Court has spoken. And the Supreme Court has said what the law is, and then that's the law.
So there aren't any specific cases?
I can't think of an instance.
It seems I was wrong about the end time, and we have plenty of time for more questions.
Oh.
So,
And I'm happy to answer them, if I can.
I'm happy to ask one.
Okay?
So it's my understanding that you taught First Amendment law for more than 10 years. No doubt in the process probably commented on the actions of previous Solicitor Generals. Solicitors
Yes,
General.
I know, it's hard.
And so I'm wondering, what was your biggest surprise when you took on that office compared to the outside view?
Well, you know, the thing that I found the thing I didn't appreciate, I would say, going in, doesn't actually have anything to do with arguments in court or briefing. It's that actually a huge part of the job of being Solicitor General is deciding what the position of the United States will be in cases that are in the courts of appeals and the Supreme Court. And you might think that's pretty straightforward, and in many cases it is. But there are lots of cases in which the executive branch, you know, including an executive branch of a given administration, where there will be widely conflicting views about what the position of the United States should be on a particular issue. And the Solicitor General's job is to make the judgment, you know, to take in all the information of the conflicting views and say, well, our position is going to be this. And that takes an enormous amount of time. You get very thorough written briefs in from, you get one from the Department of Defense and one from the Department of Commerce and one from the Department of State. And you get a memo from 3 or 4 different components of the Justice Department. And then you have to meet to kind of work this out, hear everybody out, come to a judgment. You come to a judgment, and then you may have to meet again with people based on your judgment. It's a decision-making function and a managerial function. It's an extraordinary fulfilling part of the job because you're actually, that's the place where you actually feel like you're exercising the authority of the office to try to shape the law for the country. But it's enormously time-consuming. It's a huge amount of work and a huge amount of effort goes into making those judgments. And that's not something I had really thought about. You know, people had told me it was true, but I hadn't absorbed just how significant a part of the job it was until I got in there and started doing it.
Yes.
Please use the microphone. Thank you.
Do you have an opinion as to which of the varying possible views are best on a political science basis as being best for a democratic society? That is, which interpretation of the various positions that are taken is the one that would work best for us?
On the subject that I...
Yes.
So, I think that we're generally, I think the norms that have emerged from the historical practice are the right place to be. That there isn't, I don't think you can, I just don't think this is the kind of situation where you can draw a clean line and say everything on this side of the line is okay and nothing on that side of the line is okay. But I do think that this is a power that everybody understands needs to be exercised with great restraint and with a great appreciation for the need to respect our constitutional order. And that work, I think, actually, I guess if we're going to make a judgment about it, it's that it's worked pretty well over time, continues to work pretty well over time.
Just one follow-up question.
Please use the mic.
Often, like in Brown versus Board of Education, there was really a change in what I call constitutional facts that underlied the change and the decision to reverse. What role, if any, does the Solicitor General have in determining whether to challenge a decision by using, facts not in the record, which were in fact used in Brown to overrule Plessy?
Yeah, that's a really hard question, and it gets pretty close to the kinds of judgments that we actually have to make in cases, so I'm a little reluctant to talk about it. I don't think that there's a clear rule or standard. I mean, I think in any case you're making an evaluation of the legal position and what arguments can you bring to bear to justify that position. And the one thing about the United States, as opposed to a litigant, when I was in private practice and I had a case in front of the Supreme Court, I'm representing a client, and the client's interest is in winning the case. And so I could bring just about any argument I wanted to that I thought would help win the case. When you're representing the United States, it's different because you have to keep the institutional interests of the government in mind in every case, and that means there's some arguments that might help you advance your cause in the particular circumstances, but that are going to be detrimental to the interests of the United States in a broader set of circumstances. And there's some lines of argument that you can say the same thing about. And so you just have to make situation-specific judgments in which you're thinking about all those institutional interests, and that would be true about the kind of question you asked as well.
Hi. Can you comment, are you able to comment on Citizens United and whether or not you think that'll ever be reversed?
No, I'm not able to comment on that. But thanks for asking.
I know you said you weren't going to answer on the Defense of Marriage Act, but you did say you recused yourself from that decision because of work you'd done at Jenner and Block.
Well, work my firm had done, not
Work the
work
firm
I had
had
done personally.
I was just wondering what publicly has been disclosed as to why the Solicitor General's office or the government has decided not to enforce that act, and what I assume it doesn't go into the first bucket because it's not perceived to encroach on the executives.
Well, a couple things I guess I would point you to.
And only the public stuff, I assume.
Yeah, well, yeah, that's for sure. But first thing is, just to clarify, the executive branch is enforcing the act. In other words, this is a situation like the one I described in response to the young man's question earlier, in which the government is continuing to enforce the act until such time as the courts make a final judgment about it. What it's not doing is defending the act. So it's an enforce but not defend situation. And second, the rationale for the government's decision, again, something I recused from, didn't play any part in, but the Attorney General did write a memorandum of several pages in which he sort of laid it out. I think you could Google it and find it, and you can sort of work your way through the rationale there.
It went in the second bucket.
Yes, it's in the second bucket, yeah.
Any other questions? Okay. Well, thank you very much for coming today. Let us give a round of applause.
Thank you.